Please, my lord. My lord, beg to mention item number 3. Item number 3, my lord. I'm praying for 2 weeks' time.
See, again, this is a very old matter.
My lord. My lord, here I'm being led by senior counsel, my lord, and he's indisposed, so my lord, I'm praying for 2 weeks' time.
Prayer made by the petitioner. This is matter to 2 weeks.
Much obliged.
Lordship, I beg to mention item number 2 of the main list, Lordship. This matter was supposed to be taken, Lordship, today, but Lordship, however, due to some medical emergency, Lordship, learned senior counsel could not be here, Lordship. So I'm praying, Lordship, if this matter can be taken up after 2 weeks, Lordship.
University matter, Lordship. Lordship has passed an earlier order.
Actually, I've read the order.
I think here, this is one of those four or five matters.
Exactly.
Lordship.
This is the last 2 remaining.
This is the one. This is the last one.
Last 2.
Lordship.
2015 matter.
Due to some personal medical emergency.
What is the subject matter here?
This is that MSCP matter, fixation of MSCP. Similar, I mean, similar.
Similar
but
pay scale, Lordship.
Here the facts are different. It's not covered.
Facts may be different, but if the principle is the same, then it would have been, it would have been covered by the decision in the other case.
Facts are different.
2015 matter again.
Lordship. On the next date, we'll try, Lordship, to take up this matter, Lordship. Due to some family, Lordship, medical emergency, learned senior could not be here, Lordship.
Accommodation has been prayed for on behalf of the learned senior counsel, appearing for the petitioner on ground of personal difficulties. The prayer not be objected to by the respondent, matter is adjourned. However, it is reiterated that the matter being a very long pending one, parties are requested to ensure that it is heard expeditiously. On pre-meet, this is matter up to 1 week.
Lordship.
May I please, Your Lordship? I beg to mention item number 5, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship, due to personal difficulty of the conducting counsel, Your Lordship.
Pre-meet by petitioner, this is matter up to 3 weeks.
Much obliged, Your Lordship.
What else?
Please, Lordship. Lordship, I beg to mention item number 1. Lordship, I'm paying for a week's accommodation.
I've made it clear. You see, this is a part hard matter. Now, if you keep on adjourning the matter, by the time you start, I mean, by the time the matter comes up, the next round, you have to again start from the beginning. And it's a very old matter.
1 week's time, Lordship.
Mr. Learned Counsel has sought for accommodation on behalf of the petitioner on the ground that he is not prepared to be heard in this matter today. This court has observed that adjournment has been sought for by parties time and again in this matter, and considering the fact that the matter has been pending for quite some time, it would be but proper for the parties to ensure that the matter is disposed of at the earliest. on grounds of personal difficulty, on the pre-made, this seems allowed. However, no further adjournment will be allowed in this matter. This is after 2 weeks.
Item number 4. In item number 4, I was directed to produce the record, my lord. So I'm just handing over the record, my lord. It's already the hearing and everything is over, my lord. Only I was directed to classify the record. So I have classified the record, my lord. I'm handing it over, my lord.
The written argument have been filed in this case?
Yes.
By both sides?
Yes.
I've also filed.
Mr. SD Landed Standing Counsel, GHTDC has submitted that the records as called for is produced. Accordingly, judgment is reserved in this
My
case.
lord. Hello.
I don't have anything else. What is there?
Item number 6.
It's the archery matter, Lordship.
Yes.
Lordship, in fact, CRP 11 will be, because in the other matter, Order 7, Rule 11, rejection of plain is under challenge, the order. This is under, the order passed under 94E, Lordship. I think, Lordship, CRP 11 will be much relevant.
94E.
This is pertaining to 94E order, Lordship. Once your Lordship comes to a conclusion that the
But what would the other matter is not listed today?
it's not listed, it came last week, Lordship. The other matter.
It should be listed,
Maybe together, Lordship.
together with
On
this.
the same day, Lordship.
When is it? No, fix it. To go again. I should check. Any.
September.
On pre-made by the parties, this is matter on 11th September.
Lordship. No, Lordship.
Item number 7.
In 7, I'm for the respondent, Lordship. Senior Counsel Sir Kenta is for the petitioner.
What is here?
What is here, Lordship?
Then appears for the petitioner. Mr. M.N. appears. Appearing for the respondent has submitted that this matter will be adjourned for the day. Accordingly, this is matter up to 3 weeks.
Lordship, otherwise we were ready, Lordship, for the hearing. But
No,
this is a
since
petitioner.
he's not here, what would he do?
Lordship, the observation says that I adjourn on my prayer, Lordship.
To adjourn. Mr. has is present on behalf of the respondent.
Lordship. Highly obliged.
Item number 8.
School. My lord, that we have submitted a chart. If my lord see the column wages, if my lord may kindly come to page number 7 of the chart that we have submitted. If my lord may kindly come to page number 7, my lord. Which month?
page 7.
Yes, my lord. This chart is showing reflect the contribution that we have made, my lord, for the month of March 2023, my lord. Now, my lord, may kindly see EE in the table, my lord. If my lord may kindly produce the EE contribution remitted.
E.
EE.
P.
E, my lord. E for elephant, my lord.
Okay.
Yeah. This is the amount that we have contributed for each staff, my lord.
This okay. This is employers.
Yes. Yes, my lord.
Employee.
Yes, my lord.
And employees contribution.
It's this one, I think. EPS, my lord.
How can it be?
Yes, my lord. That was what were,
Gross. See, look at the gross amount.
my lord.
Gross is 46. We are looking at.
4695.
Okay, this serial number 1.
Yes, my lord.
4695. Then
Yes.
EPF 4695.
Yes,
How can
my
it be? EPS. What is EPS? What does it stands for?
It's a contribution from the
Yes. What is the full form of EPS?
my lord, this, what is the full form of that?
Who's the PM for respondent?
And for the respondent,
Yes. What does EPS stand for?
Payment control. What is employee share, my lord, is ES. Then, my lord,
Where is that? Yes.
where's the original chart? Original. Everywhere it is written. Where's the full form of it? This is all EPF. My lord, if my lord may kindly come, EPF, my lord, is the employee share, my lord.
EPS.
How can it be?
Yes, my lord. They are showing in the chart, my lord, that they have issued to us, my lord.
PF
EPS, my lord.
or EPS?
Yes, my lord.
But how can you see? See, look at the anomaly here.
Yes, my lord.
If the gross is 4,600,
Yes, my lord.
then the employee's share is 4,600. Cannot be 100%.
Cannot be 100% correct, my lord.
Therefore, you see, even if this chart is produced,
Yes,
you
ma'am.
still have to explain to me
My lord, this
how,
chart,
how
this
it works out.
no, this chart has been given by them, my lord. We have to just pay, my lord.
Anyway, whatever, you see, either by you or by them,
Yes,
somebody
they
has
have to explain, my lord.
Because now, if you're saying that this is the employees,
Yes,
in my
That-
limited understanding, is
my
this:
lord.
there will be the employer's contribution, employees'
my lord.
contribution.
Correct, my lord.
What would be the quantum would be on the gross or
Gross,
the net
total. It has to come gross, my lord.
net
Yes.
amount of salary or gross amount of salary. We don't know.
Yes, my lord.
And when was it done? How was it done?
Yes, my lord. This is for the month of March, my lord, 2023. Let them clarify, my lord, on this because they have given us.
Clarify
Your
on this.
Lordship, my counsel for the respondent, she was about to reach, but she didn't reach till now. So, actually, she was about to meet me.
Very confusing. Where's your contribution?
My lord, may kindly come to page 9, my lord.
Yes.
This is the payment confirmation receipt, my lord. Normally, my lord, they give a demand of this and we make a payment. The payment is on page 10, my lord. Because it's online, my lord. So we have made a payment. Within 15 days, we have made a payment, my lord.
I think we have to
Because
wait
they
for-
have not given us individually, my lord. They have given us lump sum, my lord. Now it is for them to come and explain, my lord. And the number of employee, my lord, just keep on changing, my lord. It's not a fixed number, my lord. It's not like a government office where the fixed number of people are working. Sometimes the staff they left, my lord. Sometimes a new person comes and join us.
this chart. Yes, I think
Lordship,
you are not able
since
to,
the
you are not able to explain.
since my senior she is unable to come, so kindly give us any short date, Your Lordship. She will explain this. She can explain that better.
So, Mr. Day,
Yes, my lord.
according to this chart at 7 and 8,
Yes, my lord.
you have in total 25 employees.
Yes, on that particular month, my lord. That is March 2023.
That makes it more complicated.
No, because as I said, my lord, the number of employee, my lord, keep on changing. Sometimes someone leave for 2 months, we don't have an employee, and then again maybe a double number join.
They are all regular employees, or
Hello,
they are all regular employees.
they are not regular, my lord. Some are part time. Because once a teacher take leave, my lord, then we appoint it per time. Then the moment the other teacher, the permanent teacher, join back, my lord, then we have to discharge the other one, my lord. The person who just substitute, my lord. And if my lord may kindly produce page number 2, my lord.
Yes.
My lord may kindly see the number of employee, my lord. March 2023, my lord. Date of payment is on 6/7/2023. Number of employees is 25.
Where is it?
Serial number column 1, my lord. Page number 2.
Yes, column.
Yes. March 2023. Made the payment on 6/7/2023. Number of staffs, my lord, is 25. And the total amount is 32,000, my lord. 43 rupees.
I think, okay, 32.
Yes, my lord. Now, my lord, may kindly produce the next column, my lord. April 2023, 6/7/2023. The number
Where is
of
April?
is in a column table, my lord, that we have prepared. Page 2, my lord. No, page 2, my lord, of the
This is the. Sorry,
page 2.
that's why I was.
Now, page 2, my lord. March 2023. Number of employees is on 25. Now, April, my lord, the number of employees reduced, my lord, 23. So the amount vary, my lord. Then again, in the month of September, my lord, more number reduced, my lord. Now it comes to 22.
Okay.
Then November, December again 21, and then January again 19, my lord. And February 2024, if my lord may see on page 3, is 18.
February 24 is 1 or 18? Oh. How come there are two?
No, on a new staff has joined, my lord. 18 and 1. That is 19.
Okay.
Now, if my lord may kindly produce page 11, my lord.
Yes.
My lord may kindly see administration charges 0, employer shares of 4755, and then employee share of 14173, my lord. Now, it is they have to say, my lord, to us how much who is contributing for a particular individual, my lord. They give us like this, my lord, is like lump sum, my lord. So we pay accordingly, my lord.
Is your colleague coming?
Yes, she is about to reach your lordship, but
Yes. It's very confusing.
yes, your lordship.
Confusing in the sense that you have to explain.
Yes, it's a departmental matter, so it's clear instruction is there. Even we cannot say anything else.
We'll list this matter after 1 week. Premier with parties, list this matter after 1 week.
supplementary list, item number 1.
Please, Lordship.
Yes.
My Lord, in this matter, before the appellant starts, just to humbly point out, my Lord, that we have filed a caveat. Consequently, my Lord, we've been given a copy of the memo of appeal. So, therefore, my Lord, the caveat can be discharged. As far as the main matter is concerned, my Lord, let it come after about 2 weeks, my Lord. We'll formulate our submissions, my Lord.
Anyway, since you file your caveat, the matter will be admitted.
My Lord.
What is your case?
Lordship, here the single bench has passed an order quashing the order passed by EPFO Commissioner. And Lordship, it is the entire order of the EPFO Commissioner is quashed. Whereas, Lordship, there is a provision under Section 7I of the EPF Act, there is a provision for appeal. And moreover, Lordship, when any order is passed by any authority, which is a quasi-judicial authority, entire order, I find it is entire order cannot be quashed. Giving liberty to either to damage or to interest may be cut down, but quashing the entire order, it will because this is a social security legislation, it will be giving a bad impact to the societies that everyone will be following the footstep of not paying the APF dues on time.
Tell us, you see, you have just gone through, in fact, you have not even gone through the impugn order.
Lordship.
Tell us, what is the case about? What are the facts?
Lordship, we have passed an order under Section 14B7Q of the EPF Act, Lordship, and Lordship is they have not paid the EPF dues on time, and subsequently we issued notice to them, and thereafter, Lordship, we have after a proper adjudication of the matters, we have passed an order. Lordship.
Impose penalty.
Impose penalty. And damages and interest, Lordship. And thereafter, Lordship, we have, after passing the order, the petitioner therein, in the writ petition, they approached Honorable High Court. And Lordship, the single bench of the Honorable High Court has disposed the entire, disposed the writ petition, Lordship, stating that the order passed by Regional Provident Fund Commissioner is quashed, and hence the case, Lordship. We have come for appeal that entire word cannot be quashed when an alternate dispute resolution forum is there, Lordship. They need to approach an alternate dispute resolution forum, and they're taking the plea that they are government organization and need not approach alternate dispute resolution forum cannot be a ground, Lordship. And Lordship, they coming before this honorable court and not going before the appellate authority, Lordship, is the society, because this is a society security legislation, social security legislation, will giving a more impact and to the society to come directly before this honorable court and skipping all the dues, Lordship. They are not paying the dues on time, Lordship, which the beneficiary in turn will suffer, Lordship.
Lordship, if I can quickly respond, my Lord, just on the limited point of alternate avenue that is available under 7I, there is a provision of appeal, my Lord. There is definitely a provision of appeal. But the problem in this case, my Lord, is that the order which has been passed by the department is an order without jurisdiction, inasmuch as they have all the power to examine records of past years. But in this case, what has happened? They have opened up proceedings in respect of a period stretching 25 years back. So therefore, the single judge, based on the available law, based on the applicable law, has held that to open up a proceeding stretching as far back as 25 years is unreasonable. without jurisdiction, and therefore, if an order is passed without jurisdiction, even if there is an alternative remedy available of appeal, High Court under 226, my lord, the law is very clear. High Court can very well interfere, my lord.
Mr. Jin, does the law provides for such a situation? You see, in the eventuality that any proceeding is taken up after 25 years or after a considerable point of time.
It does.
So
yes, my lord, there are n number of judgments which we had submitted before the learned single judge, which we'll also submit before this honorable bench. So matter can be taken up after about 2 weeks. We'll satisfy.
Lordship, Lordship.
Heard Ms. P. Sorry, learned counsel for the appellant. At the outset, Mr. S. Jindal, learned counsel for the respondent, has submitted that a caveat has been filed before this court. Wait, can you go? Caveat. But Mr. S. Jindal, the council has submitted that in the eventuality that an appeal is preferred by the appellant here, the caveat has been filed to ensure that the respondent be put to notice. Accordingly, Mr. General has further submitted that copy of the memo of appeal has accordingly been issued upon the respondent. It is prayed that at this point of time, caveat may be discharged. On premier, the same allowed, caveat is accordingly discharged. Heard Ms. P. Ms. P. Learned counsel for the appellant was submitted that this appeal is preferred against an order, judgment and order dated 5/8/2024, passed by the learneds, passed by a single bench of this court in WPC 40 of 2023. Such judgment being assailed herein, it is prayed that this appeal be admitted. On consideration of the submission made, this appeal is accordingly admitted. As prayed for by the parties, this is matter for hearing after 2 weeks.
Okay.
Daily list, item number 1.
May it please your lordship. My lord, this is a review application, my lord, from the judgment and order dated 13/6/2024, passed in readable number 18, your lordship. Initially, my lord, there was some delay in filing. So delay on last occasion, lordship has condoned the delay. And as I sought some correction, my lord, that we have done. And my lord, so I'll make my why I sought for this review, my lord. I am fully conscious about the, my lord, very narrow scope of review, your lordships. Now, my lord, before I get into it, your lordship, very briefly.
We'll see what is the apparent.
Apparent, my lord. I'll just come to that. Before that, my lord, lordship, very briefly, my lord, 2 minutes, my lord. Timeline before the division bench, my lord, leading to this judgment, my lord. In fact, this writ appeal was filed, my lord, on 5/4/2024, your lordships. It came up for admission on 9/4/24, my lord. A prayer was made on behalf of the state government for some accommodation, so the matter was posted again on 7/5/24, your lordships. And 7/5/24, my lord, one of your lordship was in the bench, matter was admitted. And of course, there is also an order, though it is not reflected, my lord. There was an order that respondent, if so wish, they can file a objection. That was the thing, my lord. And then it was posted on 13/6/24, your lordship. Now, 13/6, till the previous day, my lord, I was making inquiry if any objection was filed, my lord, none filed. So, in the situation, my lord.
Objection to the condonation
No, retable, my lord. I'm just talking about the retable before the division bench, my lord, leading to this judgment. So, my lord, ultimately what happened, my lord, the objection was not filed. So, I just made a request to my colleague, Ms. Shalam, my lord. The other side might seek some time for objection. We should not object to that. Otherwise, just seek an objection. I may be little late, my lord. Somehow, my lord, other side, in fact, sought time for accommodation. That was not permitted. And the matter was decided, my lord. I could not make it. But anyway, I do not have any grievance for that. The court can decide, my lord. I have no grievance for that. So, ultimately, my lord, when I went through.
You mean to say that when the matter was disposed of by this court,
Lordship.
It was on the basis of
Well,
not on the merits.
No, it has been decided on. Now, what happened, your lordship? The objection was not filed. So, I was under expectation the state government will seek some time. So, I instructed my colleague, Ms. Shalam, my lord, if they seek any time, my lord, I think we should not object, your lordship. Otherwise, my lord, if the court takes up the matter, my lord, I'm just trying to make it. You seek some accommodations. So, they, my lord, sought some time for filing opposition. That was not allowed. So, court has gone into the merit, heard them, my lord. I have no grievance for that. I have no grievance for that. Heard the matter and decided the matter. I have not just please.
It was decided in your absence. Only your colleague was.
No, I understand, my lord. If one of the colleagues is, my lord, sufficient enough.
You could not personally be.
My lord.
You could not be present.
My lord. Now what happened, your lordships? Now I'll come to the merit of the case.
My lord,
now, my lord.
If I'm just allowed to clarify on that part, my lord, as far as the objection is concerned, my lord. Yes, no doubt we had sought time before this honorable court. My lord, earlier time was granted. But my lord, on that very day, my lord, the court had come to a decision that objection was not required, my lord. So, my lord, the decision was given on whatever records were available before this honorable court, my lord. So, that is the case, my lord.
My lord. But it was decided
on the records available,
my lord. I'm not saying, my lord. Based on the records, ultimately the judgment has been passed. Now, my lord, I have gone through the judgment. Now, here, your lordship, I'll have to place what was my case, my lord. Sometime. Now, my case here, your lordships, before the single bench, that at the relevant time, 3 number of writ petitioner, they are holding the position of assistant professor, holding the post of assistant professor. Now, my lord, what happened in following the 6th pay revision by the central government, MHRD carried out a pay revision for teachers of central and deemed universities, not state. Now, they formulated a scheme. Then ultimately, sometime, my lord, in if I remember correctly, the date was 31/12/2008. They circulated, my lord, they released the scheme. Now, this is mainly concerning with the central and deemed university. But in the bottom, there is a provision, my lord, where an option was given to the state government, saying that if you desire, you can adopt it in those institutions which are under your legislative control. And the pattern, my lord, of my lord funding, that was stipulated that initial 5 years, my lord, this starts from my lord 1/1/2006. Initial 5 years, whatever be the additional expenditure, these would be borne by the 80%, to the extent of 80% would be borne by the central government, MHRD, and 20% by the state government. Now, my lord, as per this pay revision, my lord, provides what is the pay scale of the teachers serving in the central university. And they are required to fulfill the UGC norms. They said, my lord, this is the pay scale with multiple opportunity of, my lord, moving to the higher academic pay grade, starting from 6,000, 7,000, 9,000, my lord. Now, the scheme further says that in case of a movement to a higher academic grade pay, the teacher would be entitled for a, my lord, my lord, what is this? Financial, my lord, increment, additional increment, would be entitled to additional increment.
Great pay.
Great pay. From movement to 7,000, 6,000 to 7,000. Moment he is placed in a 7,000, then he will be entitled, while fixation of pay, my lord, an additional increment is provided. Now, this is not disputed, my lord. Government of Meghalaya consciously adopted this scheme. Again, there is a stipulation in the scheme, my lord. It hurts like a scheme. It's not a scheme. I'll come to that, my lord. It virtually became a legislation. Because this scheme cannot be, my lord, implemented unless it makes into a rules. Now, who makes the rules? The scheme is very clear and categorical. The scheme say, my lord, scheme say that this can be implemented only when a rule is made in this regard by the UGC. Now, my lord, UGC lordship is the University Grant Commission. They normally regulate, my lord, central university and deemed university, not the state university. Now, my lord, under the UGC Act, regarding the condition of service, emoluments, etc., from time to time, UGC has the power to formulate rules. And my lord, those rules are placed before the parliament and approves. So this is an act of subordinate legislation. So Meghalaya government, my lord, adopted this. Subsequently, and in their, my lord, resolution, they have said regarding pay fixation and other things, we will follow the rules of UGC. They will have to. No other option. So those things were there, my lord. I will not go into very details now at this stage. Now what happened, your lordships? So far, these three writ petitioners are concerned. They were placed to a higher academic grade pay by an order dated, my lord, 1st December 2014. So moment they pay in a higher academic grade pay, at the time of pay fixation, they are eligible for additional increment. That was not given. That was not given. We filed representations. My lord, I have not annexed all the representation before the single judge in my writ petition. I annexed, my lord, 2 sets of representations. The reason is this: ultimately, this was answered by the Director of Higher and Technical Education and answered in my favor. Now, what is say, my lord? These say this is dated, my lord, 24th August 2020. They said, yes, we have examined the rules and the Director of Higher and Technical Education is of the opinion. There is no individual opinion. This is the opinion of the Directory that these teachers are entitled for an additional increment. This is the reference to the UGC regulation and the same scheme. That was done. Now, thereafter, what happened, my lord? August it was passed. Now, in 21 June, we filed a representation remand. We are expecting now it will be done. We waited almost 6-7 months, nothing happened. We filed our representations. Now, that was not answered. Representation means we said that whatever directorate has said, please comply with it. So that was not done. Ultimately, in June 2022, your lordship, we filed the writ petitions. So far we are concerned, our submission before the London single bench is, there is no delay at all. Now, my lord, there is so far, my lord, writ petition is concerned, my lord, there is no limitation act is not applicable. But it does not mean, my lord, I am slipping over my right and coming after long delay, my lord. Here in this situation, my lord, there is no delay at all. Now, what happened, my lord? There was a long hearing, my lord, continued for quite some time. Now, state has raised many objections, technical objection and other way. Now, after hearing the submission both sides, so far my right of an additional increment because of the scheme and the UGC regulation, learned single judge has declared I have a vested right. Vested right. My lordship will see the status of what is a vested right. He declared, yes, these teachers have a vested right to have their additional increment. But the relief was refused on the ground of only delay. Now, my lord, I was harping heavily on the latter communication made by the Director and Higher Technical Education. In fact, my prayer in the writ petition is direct respondent to comply with the order issued by the DHT dated such and such. If your lordship want, I will take my lord. That was my prayer. So my consistent stand before the single judge, because of this letter, there is no delay. Now, my lord, here if your lordship look into the finding, very tentative finding of the learned single judge came to a finding that even after this letter there is a delay, unexplained delay. Well, that representation or attachment, that was not a representation, well, an attachment immediately after the communications. So even after this not allowed. So in the situation, my lord, that's the view of the learned single judge. I filed a writ appeal. Now the other issue also I raised before the learned single judge, that was also not done. This is a statutory right. This is not a scheme. This scheme has been, my lord, this scheme has been made as Appendix 1 to the regulation formulated by UGC. So it became a part of the regulation. So this is an act of, my lord, subordinate legislation, and that has been answered by the Supreme Court even. So that was my submission. So, my lord, ultimately I filed an appeal. The contentious issues I raised before the division bench. There is no delay. Why there is no delay? Though it was passed 2014, the placement, my representation ultimately answered in my favor by the Director and Technical Education in 2020, and thereafter a representation was there. So there is no delay. This is one. Secondly, it's a statutory right, because this is a right incorporated in the regulations, my lord, which was made in exercise of the subordinate legislation by the UGC. These was the two contention. In fact, my lord, so far this scheme is concerned, my lord, they provide what are the qualification of the VC other day. Now, one of the issue regarding the same scheme, which has been made into a regulation, reached the Supreme Court. Now, what the Supreme Court answered, I placed that decision. What the Supreme Court said after examining it, said, since the state government has adopted this scheme, that means they have brought in the regulation of the UGC. Now the Supreme Court discussed what is this regulation. This is a regulation made by the UGC, placed before Parliament. Once it is adopted by a state government, it is expected that the state government will fall in line with this regulation by bringing necessary amendment in their law or regulation, state law. And if they are not doing, no problem. The doctrine of repugnancy, because education, my lord, this belongs to concurrent list. Both the state and the central government can make law, but ultimately in there is a clash, it is the central law that will prevail. So that has been settled by the Supreme Court. Now these were some very serious issue I raised before the division bench. Now your lordship, I will not waste my lord's time, but these issues were not even touched. I will just take my lord to the judgment in the review application, page 15. Relevant parts start from page 16, my lord.
Yes.
I just read it. The present appeal has been preferred against the order dated such and such in writ appeal such and such. The case of the appellant writ petitioner is that they are teachers in a deficit college and serving as assistant professor has preferred the writ petition jointly on the ground that they have been placed at a higher stage of academic grade pay, but they have been denied the increment which they are entitled to. According to the appellant's writ petitioner, there was a scheme of 2008 which recommended the grant of increment in terms of 6 central pay commission, and though the government of Meghalaya has adopted the said scheme on 13/12/2008, there was no payment made, even though the same has also been accepted in terms of UGC norm as early as in the year 2010. According to the appellant writ petitioner, the professor are entitled to additional increment with effect from 2013, as could have been seen from the representation dated 3/2/2020 made to the principal. The relevant portion of the representation, on the basis of the above facts, the denial of granting 3% increment at the time of fixation of the pay at the time of my placement on 16/4/2003. Here, lordship, there might be some confusion, lordship. This 16/4/2003. This placement was made by an order issued in December 2014. Order was issued 2014. In any case, I could not have challenged my lord before 2014. From the post stage 1 to the post stage 2 of the assistant professor in the payment of such and such, on whatsoever reason, in complete contravention of MHRD latter dated UGC regulation 2007, clarification on such and such. Even though, according to the appellant's writ petitioner, the professor are entitled to 3% increment at the time of fixation of pay and at the time of placement in the year 2006, there is no whisper till a representation dated 3/2/2010 has been made. From a typeset of the documents, there appears to be another representation 7/2/2020 requesting for granting of the additional promotion increment at the time of such and such in the pay scale of such and such during 6th pay and refixation such and such. The additional increment which the appellant writ petitioner claim is not a continuous one. The cause of action is not continuous and it has no bearing with regard to the grant of other benefit, as it is not going to affect the terms of such and such. Taking note of the fact that there is a delay of more than 8 years in making the representation, the learned single, my lord, here if I can pause for a while, even that 8 years is apparently, my lord, wrong, because placement was issued with retrospective effect by an order issued in December 2014. Though, my lord, the court has referred to my representation dated 2020. Even before that, they were representation. I had not any. 2020. My lord, from 14, going by a simple count, your lordship, it can be 6 years. It cannot be 8 years. More than 8 years, the various judgment came to the conclusion that no relief can be granted. The representation has been made only in 2020, when according to the appellant, the writ petitioner, they are entitled to the benefit as early as 2013. On the sole ground of delay and laches, approaching this court, we are inclined to refer to paragraph 10 of the judgment and order of the learned single judge for rejecting the plea of the appellant writ petitioner on the ground of delay and laches. Paragraph 10 of the judgment, my lord, this is reproduced from the judgment. This is a judgment on delay and laches. Now, my lord, then, my lord, lordship will come to page 19, my lord, the operation part. The additional increment is not continuing ground, and that the appellant's writ petitioner have slept over the matter for more than 8 years. We cannot take up the sleeping person from the slumber to grant the relief according in view of the above, and the professor have accused their right to the writ appellant is dismissed. Now, your lordship, what is my prayer? Where is that letter? Crux of the issue is these two issues. One is it is a statutory right. There is no discussion. That is what I raised. These were the basic grounds I have taken up in the writ appeal. And in my writ, lordship, I think the record is here. Records are there. If I can take my lord to the writ petition. The writ appeal. In the writ appeal. The writ petition. What he said. And my lord, the other part, if I can submit your lordships, the ground of review, my lord, 114 and my lord 47, 3 part. One is, my lord, certain facts at the time of hearing could not be done. I am not on that. Other is error apparent on the face of the records or any other good reason. Now, error apparent on the face of records and erroneous decision. The task has been well laid down by the Supreme Court, my lord. I have that judgment. Error apparent in the face of the record, my lord, for which we don't need to make an intense submission or exchange of reasoning. Because here, my lord, that's what I'm exactly trying to point out. My crux of the issue is that letter dated, even that my prayer, your lordship. Kindly, your lordship looks into the...
See, Mr. Sen, if you say that the appellate court,
lordship.
When the writ appeal was taken up, if there was an erroneous view taken by the court, that could not be a ground for.
No, that is why I'm saying there is a distinction between
Erroneous
error.
view as far as facts are concerned.
Exactly, my lord. Here, my lord, the issues I have raised, not even referred to, not even discussed. What are the issues I have raised? Because there are two things, my lord. Error apparent on the face of the record. This is a case falling within the, my lord, ambit of error apparent on the face of the record, not erroneous decisions. Now, my lord, I'll refer to that judgment of the court. Now, if your lordship, if I can take my lord to page 60 of the writ appeal.
Mr. Ustaji, you prepared to be heard in this matter?
My lord, few points, my lord. Of course, I will, if the honourable court permits, I would like to file objection, my lord. Because, my lord, my senior, my senior, my lord, is opening up the whole issue, my lord. He has already argued all these facts thoroughly before the learned single judge. Even, my lord, at the time of the admission also, my lord, these facts were argued before this honourable court, my lord.
The point that what we are asking you is this. Mr. Sen has already opened up his case
My lord.
on merits, and we're hearing the matter. We've heard him at length. It would be your turn to respond.
So, my lord, if this
You see, we don't want to. See, after he has gone on for half an hour or 1 hour, you'll say no.
so, my lord, if this honorable courts permit for an objection, I will file an objection. Otherwise, I'm ready to hear take up the matter. my lord.
Everything based on records.
Matter of record.
Nothing else. My lord, I am not. My learned friend is anything beyond the records. My lord, I will not make submission.
My lord, he is open. Fact, my lord, in my respectful submission, scope of review is very limited, my lord.
That would.
But my lord, my learned senior is opening up the whole issue, my lord, whole detailed facts, my lord. All these facts are already gone into by the learned division bench, my lord.
See, that would be your argument.
Yes.
We are, we are prepared to hear that. The only thing is, are you ready now?
He's ready. Yes,
Don't say afterwards that.
Lordship, only my lord, these facts I have placed just to appreciate, my lord, what are the issue I have raised, nothing else. I am not asking for any.
As it is, it appears to be finally hearing the matter.
Mr. Sen, do you say that he doesn't have a right to file a suppose against review? Can he challenge the maintainability of review?
My lord, pays the scope, your lordships. That's what my
question. Why not?
Have I said anything beyond the records? I have not said anything beyond the records.
So you want to say that no suppose is permissible in a review application?
My lord,
unless
my lord, unless something, my lord, beyond the records I am placing. I am not placing anything beyond the records.
See, according to you, you are saying that everything is within the record.
No.
He may not agree with that. He may say
he has never said, my lord, I am making submission beyond records. He is not saying. If he say that I have brought a documents beyond the records,
see, simple thing
this is ultimately up to the court, my lord.
See,
up to the court.
Are you taking a stand that no suppose is permissible in a review?
No, I am not saying that actually. What I am saying, my lord, this court has the discretion, my lord. This court, the ultimate discretion is with the court. What I am saying, my lord, I am confining my submission within records, your lordship. No, I made it little elaborate to appreciate the issue.
In any case, we will still consider your contention or your submission,
lordship,
and we will not allow them to file a show cause.
Exactly, my lord. So that's what I am saying, my lord.
But my brother is saying that the principle.
No, my lord.
The fact is this
is the discretion of the court, my lord. I will not say no, my lord. This is absolutely the discretion of the court.
I've noticed. You see, I've noticed here.
Lordship.
Even in the writ appeal, they still file affidavit. Still file objection. Which is allowed.
Sometimes even the court asks your lordship. Even in this case, like objection was.
That becomes a special permission.
It's
not a regular permission.
We are flexible.
But if you take a stand.
No, I will not say. What I am saying, my lord, my endeavor is I am within records, but lordship may feel, my lord, he may be given an opportunity.
One thing is that, whatever the thing is that, review is not a matter of right.
Lordship.
Is it all right? You accept that proposition of law. Now, when you come up with a petition, which is exclusively your right, in such a case, suppose is always allowed. In appeal, statutory appeal, that is your right. Say like in civil matters, first appeal, it's a matter of right. The suppose is not at all required. But then review, since it is not a matter of right, he has a right to file a suppose.
No, that is
what perhaps the understanding of until you dispute it by showing something.
No, my lord. No, what I am saying, my lord, scope is narrow, my lord. 3 part.
Definitely.
Now, whether this is only thing your lordship will see here, whether there is error apparent on the face of the records. Now, what are the test of error apparent on the face of the record laid down by the Supreme Court, my lord? Now, here my whole case. That's why I want to take my lord to page 60. The prayer made in the writ petition. Now, what is my prayer? If I can take my lord for a while to page 60.
First,
page 60, your lord.
We turn to Mr. Prasad.
My lord, as far as I am concerned, my lord, I would like to file an objection, my lord. Because according to me, my lord, this review itself is not maintainable.
Now you are trying to take advantage.
No, my lord. Why I am telling, my lord?
That
because
was not your original prayer. You did not say it at the beginning.
You should have said, my lord.
Should have. Until unless you have anything to raise, why should you file a suppose? Just to buy time.
My lord, there is no, in my respectful submission, my lord, there is no error apparent in the face of the record, my lord. Now, the learned division bench, my lord, while passing this judgment, my lord, all these facts have been considered. Now, my lord, it is also because, with due respect, my lord, because my senior had earlier stated that he was not available, my lord, and this order was passed.
I never said
my
that,
lord,
my lord. This is
it
wrong.
is
What
now,
I said, I could not make it by Shalama. The way you are making wrong and distorting my submission.
My lord,
don't distort. I said court can pass the order. Shalama was there. I could not be there.
No, lord, my respect.
The court cannot pass an order.
That issue has been dealt
with. No, my lord, my respectful submission, my lord. That day, my lord, the learned division bench, my lord, extensively went through the record, my lord. Only 1-2 questions were put, my lord, where answer was required. Other than that, there was no hearing from either side, my lord. It was primarily, my lord, gone through the record in detail. All aspects were gone into.
We are
Then
not
this,
into that. We are not into that now.
my lord,
See, now we have to concentrate on what is before us.
my lord.
If you say again, I'll repeat myself. If you see that you are ready for a full-fledged hearing, we'll take it up. Because we don't want to waste the time to court. Like I said again, after some time you'll say no. As far as filing
But you
of show
should have
cause,
said in the beginning, man. We
That's
should
what
not
I'm
have taken up this exercise.
My
Your Lordship.
apologies, my lord. But if I am permitted, then I would like to file an objection, my lord. Otherwise, I will go by verbal objections, my lord.
My lord, what is wrong if my learned friend is making verbal objection? Your Lordship say yes to
where is
hear.
the scope for objection?
My lord,
In your
my lord, there are,
in your argument, you can point out whatever is there available on record.
my lord,
Whether this
there
court, whether this court, when passing, while passing the order, has has erred in any manner.
no, it has not heard, my lord.
Obviously, my lord,
If you want to
let me complete.
then you have to.
Let me complete, then
you have
he
to
can
make
say
your,
that good. There is
you have
no
to make your,
nothing
you have to make your
apparent.
stand and supported by authorities. That's all.
Yes. Yes. Then I can continue, my lord.
Let him say. You wish to respond or not? We'll not have it piecemeal. If you're not prepared, Mr. Charjit.
My lord,
Tell us.
so, my lord, let it come up next week, my lord.
My lord, only thing, my lords, because I have the experience before single bench also.
No,
This
no,
matter
this-
was dragged on. 3 affidavits were filed, my lord. It should not be adjournment after adjournment. When my learned friend appears, my lord, we have
My lord,
apprehension.
these-
Apprehension
You
in the
know
bar.
very well-
In the bar, my
Affidavits
lord.
are
You know very
My
well,
lord,
Mr.
this cannot be
unfortunate.
made. This
See,
sort of
parties-
submission cannot be made by my
Parties
senior
are
as well.
aware.
The apprehension in the
My
bar.
lord, affidavits are filed because certain
affidavits.
clarifications are required, my lord. And the honorable court has given us permission. It is not that. Now the
Only thing, your
department,
lordship, ensure that it's
my-
taken up next week.
my department, then let the matter be taken up today, my lord. I am ready. I am ready.
Now, if your lordship, if I can take my lord to the prayer. Page 60, my lord, of the writ appeal. Page 60 of the writ appeal. Well, you got it.
Yes.
In the premises aforesaid, it is therefore humbly prayed that your lordship may be pleased to consider the above, call for records, issue rule calling upon the respondents to show cause as to why a writ of mandamus shall not be issued, declaring the inaction on part of the respondent in not granting additional increment to the writ petitioner on their placement in each highest stage of the academic grade pay in the post of the assistant professor, and thereafter fixing their pay in the appropriate state in spite of recommendation in this regard contained in the letter dated 14/8/2020. This is the letter where I am saying there is not ruling. That is the communication made by the Director of Higher and Technical Education. They said, yes, we have examined in detail the matters. They are entitled. Please consider their case. So after that, what I did, and this is the part of my prayer, I heavily relied on that. So when the learned single judge, I'll take my law to the judgment of learned single judge. What the learned single judge finding with regard to my entitlement? What is his finding? He said, yes, we agree, you have a vested right. Learned single judge has acknowledged that we are entitled for additional increment. Only ground it was dismissed. Late. Of course, the other ground, my lord, heavily taken up by the state, that my petition is vague because I have not quoted the pay scale. So I'll come to that, my lord. That was not required. So learned single judge, though observed, my lord, on that ground it was not dismissed. So my humble submission, your lordship, the crux of the issue is letter dated 14/8/2020. And that it is a statutory right?
Yes.
It is a statutory right, my lord. Now, if your lordship, if I can take my lord to the relevant part of the finding of the learned single judge. Where is the judgment? Well, the judgment starts from page 176. Well, only the relevant part I'll take, my lord. I think from 6 it will do, your lordship. 182, paragraph 6. 6 onwards, my lord. That's the finding starts from here. Having heard the learned counsel for parties, in spite of the lengthy submission that have been advanced, the core question, as can be understood, is limited only to the claims of promotional increment, that is the additional increment, my lord, on the petitioner being placed on a higher stage of academic grade pay. This is seen was as per the Ministry of Human Resource Development Scheme, revision of pay of teacher, etc., on the recommendation of 6th Central Pay Commission dated such and such, which was adopted by the UGC in its regulation 2010. Now, this has been incorporated in 2010, and we have extensively referred to this, my lord, before the launching. Undeniably, the petitioner have been placed in the highest stage of AGP from stage 1 to stage 2 at the relevant point of time, which would have clocked them with a vested right to the promotional increment, as provided by the scheme.
He's referring again to the facts. What do you intend to convey by leading us to this judgment?
Leading to this judgment, with the crux of the issue is my communication. I have heavily relied with. There is no delay because there was a communication from the DHT, Director of Higher and Technical Education, dated, my lord, 24/8/2020.
So you want to say that the judgment which held that there was a delay of about 8 years, that is not correct.
Not correct. That is, and what is the finding, my lord? That's how I want to take. What is the finding on that letter? There is some finding. Division bench, there is no reference of this letter. So that's what I'm saying. This is an error appearance on the face of the record. So for the division bench judgment is concerned. So for single bench, yes, there are some tentative finding with regard to this letter. But this should have been decided, my lord, in the writ appeal. But these were the contentious issue, my lord. I'll read out the grounds I have taken in the appeal. Now, my lord, you say that it's clocked with a vested right. Then he said, provided the scheme by supported by the government to the extent of 80%, etc., my lord. Now, your lordships, if I can take my lords. Now, 7 also, my lord, I can read if your lordship bear with me. That learned single judge was discussing about the scheme and the money was disbursed in 2015.
What is the relevancy of single bench? What single bench was saying in a review?
No, what I want to point out, my lord.
You are seeking review of a judgment passed by division.
Exactly, my lord. Just to appreciate the fact, the content, why I what were my contentious issues.
Then you are basically, your submission goes against the very principle which you see. What is the law? See, what is apparent? What is error apparent on the page? You see, that means that you do not have to make any roving inquiry, roving search.
Exactly.
Something is very apparent.
Anyway.
Now, if you have to establish ground for review by referring to the single bench judgment, that amounts to roving inquiry.
No, I will not know. I will close it. Then I can take your lordship to the grounds I have taken in the writ appeal. Because these only to justify the grounds I have taken. My lord. Those issues were not touched even. One is 24/8, my lord. There is no doubt. Only if I can say what is the finding of the learned single judge. Finding of the learned single judge on 24/8, my lord, 2020. Though that letter is there, even after that there is a delay, unexplained delay. But the fact on record, even after this letter, there was a, my lord, representation dated 21st June 2021. So that was not even discussed by the learned single judge. Then the writ petition was filed in June 2022. So there cannot be delay, my lord. Writ petition, there is no limitation. It cannot be saying, my lord, I am barred by delay and lecture. Now, on this ground, I will not get into it. Now, what are the issue I raised, my lord? That I will take, my lord, before the division bench. The grounds for appeal, your lordships. Where is the ground for appeal?
See, Mr. Sen, as far as I could understand
Lordship.
is if the division bench, having heard the parties and on appreciation of the impugned judgment,
Lordship.
has made its decision,
Lordship.
pass an order.
Lordship.
Some points may have been left out. Some may.
It's not a question.
Some
Some
may have
point,
been-
my lord, the main
some may have
contentious
been.
issues
So,
have
but
not been
those
touched.
are- see, those I don't think that those are a matter of review. They would be matter of appeal, no doubt.
I'll come, my lord. I have not finished. Now, what is appeal? Erroneous decision. What is error apparent on the face of the record? That task has been laid down by the Supreme Court. My lord. If I can complete, and then I go back to the decisions. My lord, page 26
Of
of the appeal, my lord. These are the grounds, my lord. I am not going to single bench anymore.
yes.
Lordship, if I can start, my lord. 6.2.
6.2.
Ground 6.2.
Yes.
For that, the learned single judge, having acknowledged the writ petitioner right to have promotional increment for placement from stage 1 to stage 2, ought not to have dismissed the writ petition on the ground that delay and laches when the issue was alive and pending before the respondent, as would be evident from the letter dated 4/8, my lord. Again, this is the crux, 24/8, with the director such and such. Now, my lord, I will not repeat. Same in 6.3, again 24/8. But that was the most contentious issue. That was part of my prayer. The learned single judge failed to appreciate the non-granting of promotion in amount to continuous wrongs. For that, the disbursement of financial assistance of 80% expenditures, my lord, this is another ground, my lord. This is also no way, my lord. What happened before the learned single is just somehow is coming. They say the central assistance came sometime in 2015 or 16. So after the central assistance came, it is everything over, nothing survives. That was the stand of the case. So whatever it may be, I have taken, this was not even touched. Then, your lordship, 6.6, for the single judge holding that the writ appellant approached the honorable court 12 years. My lord, that is even, my lord, where from the 12 years comes, that is of course of the single bench. This should have been corrected at least, my lord, because placement order was December 2014. And if we add, my lord, cause of action, any starts from there. Now, if we add 12 with 2014, it comes 2026. Writ petition was filed in 2020. So even if you go by simple arithmetic, my lord, it is from 14 to 22 when we filed the case, it's 8 years. So these are, my lord, apparent. But then these I raised before the division bench, my lord, to appreciate. So these was not looked into even. The increment, why not go? So these were the, my lord, and then 6.8, if your lordship, you understand?
Yes.
So, my lord, what I want to say, the crux of the issue is, my lord, 24/8/2020, that letter. That is what I hesitated. These were my substantive submission before the court. Now, these were not even noticed. Not even had it been referred to, my lord, even without discussing, my lord, then an order has been passed. Then I could have said it's an erroneous decision. So this is an error apparent on the face of the records. Now, my lord, what the decision say? 1997, my lord, I have given the list of the book. 8 Supreme Court 715.
There are two different letters. Mr. Shah, in your prayer, letter is dated 14/8/2020.
Which prayer, my lord?
Your prayer in the retexting at page 60.
Page 60, my lord. I'm just. This is the page 60.
Letter dated, yes, sir.
See,
14/8.
My lord,
this
that.
reference of letter is 14/8. Now come to your grounds.
24.
Page 26.
24.
It is 24. What is
That's
correct?
typographical error, sorry. It's stand corrected here.
Oh, you know, for us it is confusing.
No, my lord, 24. Right?
This may refer to two different letters.
No, my lord, there is no letter for it. Anyway, I'm sorry, my lord. This is a typographical error.
But that should have been.
So what is correct? Which one?
24.
That should have been
I have annexed that letter, my lord. Can I take your lordship to that
It's
letter?
alright. You say it's 24, it's okay.
No, I have annexed this letter. This is at page, my lord. Page 123.
It's okay. If you say 24, we are taking it as 24. We are not going to disbelieve you.
No, even then, my lord.
You want
Should not have been.
clarification on the
123, my lord. 123/24. Letter dated 24th August 2020. Followed by, my lord. Followed by next page, another representation 24th July 2021.
Yes, please.
Now, my lord, what
No, what the judgment you have cited?
reference, my lord? Before the reference, shall I take, my lord?
No, that
to
judgment you have
that
cited. is
CPC, my lord. Just CPC, the grounds.
No, 197, 1997.
1997, volume 8, page 715.
Para.
Para 9 and 10.
What does it say?
Just read para 9 and 10. Under Order 47 Rule 1 CPC, judgment may be open to review inter alia there is a mistake or an error apparent on the face of the record. An error which is self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its review power. In exercise of the jurisdiction under Order 47 Rule 1 CPC, it is not possible for an erroneous decision to be reheard and corrected. A review petition, it must be remembered, has a limited purpose and cannot be allowed an appeal in disguise.
This was this was the observation I had made.
My lord, I am coming. Yes.
Anyway, we are not. That was just an observation.
Lordship.
Can.
Now, considered in the light of the settled position, we find that Sharma clearly overstepped the jurisdiction vested in the court under 47(2). The observation Sharma that accordingly the order in question is reviewed and that it is held that the decree in question was to be a composite nature, wherein both the mandatory decree in question was composite in nature, when both mandatory and prohibitory injunctions were provided. And as such, the case was covered under Article 182 and 181 cannot be said to fall within the scope of 47. There is a clear distinction between an erroneous decision and error apparent on the face of the record. While the first can be corrected by a higher form, latter can be corrected by exercise of the review jurisdiction. While passing the impugned order, Sharma J found that the order in civil revision number dated 25/4/1989 as erroneous decision, though without saying in so many words. Indeed, while passing the impugned order, Sharma J did record that there was a mistake or an error apparent on the face of the record which was not such a nature, which had to be detected by a long drawn process of reason and process to set at naught the order of Gupta J. However, mechanical use of statutory sanctified phrases cannot detract from the real import of the order passed in exercise of the review jurisdiction. Recourse to review petition in the facts and circumstances of the case was not permissible. The aggrieved judgment debtor could have approached the higher forum, though such and such. So, my lord, I am not denying the fact that should be an error apparent on the face of the records. Now, my lord, the contentious issues, my lord, I have gone through. My contentious issues, my lord, including the prayer before the single judge. Why I refer to the single judge? Crux of the issue is the letter dated 24/8/22. This is the crux of the letter, followed by a representations. So that is what was called for the division bench to answer. Now these were not even noticed. Had it been noticed, my lord, otherwise, that yes, we have looked into this letter without reasoning, it could have been said that this is an erroneous decision. But here is a case, my lord, lordship will go through, my lord, I have gone through repeatedly this judgment. These were not even noticed. My crux of the issue is this. So, my lord,
Can you read this letter 28/8?
24/8.
24/8, sorry.
Lordship. Page 123, my lord. 24(8) to the Joint Secretary, Government of India, Education Department. Pay anomalies. These are basically anomalies, my lord. Not granting a pay increment. Normally, these are sorted out by the departments. With reference to the subject mentioned above, I have forwarded here with the receipt from the Business Standard College, including the representation of such and such Assistant Professor English, along with the enclosure, wherein they have pointed out anomalies in pay fixation on being promoted from one grade to another grade pay that has arisen out of non-implementation of promotional increment as envisaged in UGC gradation list such and such. Insofar as UGC regulation 2010 is concerned, the following clauses clarify the pay fixation formula. Clause 8b states that pay fixation formula recommended by the 6th Central Pay Commission as accepted by the government shall be adopted for teachers equivalent position in library, etc. Clause 8a such and such, the number of additional increment on placement at each higher stage of HGP shall be as per the existing scheme of increment on promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in effective pay between the two bands, there shall be no additional increment from pay band to this. Clause UGC Regulation A indexably linked clause 13 such and such. Accordingly, while fixing the pay in promotion of higher pay band, an additional increment of 3% of pay in the existing pay band is added to the existing pay band. The AGP corresponding to the promotion post will then be granted in addition to this pay in the higher pay band. Insofar as UGC Regulation 2018 is concerned, the following clause clarify the pay fixation formula on promotion from one pay level to another. Clause 19.2 states that promotion when an individual gets promotion in his new pay on promotion would be fixed as per the pay matrix. On promotion, the teacher or equivalent position would be given a notional increment in his or existing academic level pay by moving him or her to the next higher cell at that level. And the pay shown in the cell would now be located in the new academic level corresponding to the post to which she has been promoted. If a cell identical with the pay is available in new level, that cell shall be new pay, otherwise the next higher cell. If the pay arrived in at the manner less than such and such. Now, my lord, this is important. In view, the view of this directorate is that the teachers are well within their right to point out the anomaly so described above, since while extending the UGC pay scale, it seems the pay fixation formula also needs to be followed in totality. In view of the above, government is requested to kindly extend the promotional increment with promoting the teacher, both government college, deficit college, aided college, stage, access for promotion, as per UGC Regulation 2010. That's what I'm saying. So it's very clear, my lord. They have taken a decision, and that's why I have referred to this. Now, what is the, if I can take my, I didn't know, single judge, what is the finding of the single judge? Some kind of acknowledgement is there, very tentative. But at the same time, what is the explanation after this? Now, learned single judge say, even after this, there is a delay. But there was a document, my lord, immediately behind it, 125. 125. 25 representation such and such. Now this is by the teacher. Now there, my lord, 3 they have referred to this letter 24/8/2020. With reference to the subject above, we undersigned would like to request you to look into our petition as early as necessary in petition. It may be brought to your kind attention that our petition have been favorably considered, recommended by the such and such. So this was not discussed. So whatever it may be, my lord, I am not raking up that issue, your lordship. What I am saying, these were the issues, my lord, core issues. No, core issues not even noticed. Is it not an, my lord, error apparent on the face of the records? I make a long submission, my lord, only to my lord, make understand, my lord, what is happening. So my humble submission, your lordships, these orders need to be recalled and matter needs to be heard. None of the issues has been touched. Because moment you say, my lord, delay and lectures, at least this should have been referred. We looked into this letter. Anyway, this letter and the finding, even the division bench could have finding of the learned senior judge, we do not find any reason. This was not noticed, my lord. Even if it is not noticed, not reflected in the order, my lord, that my humble submission, that is an error apparent on the facts of record. And this is something, my lord, not a peripheral issue. This is the core issue. Everything depends on this letter. So my humble submission, my lord, this is a case, my lord, call for, my lord, need to be recalled and matter need to be.
That is as far as the issue of delay is concerned.
No,
on your part, you say that since you have made a representation or rather reminded the authorities concerned, as early as 2021. So there is no delay.
That representation also not referred to my lord. So there is no delay. Even from the date of this letter. Now this letter was August 2020 and I filed the writ petition, my lord, in June 2022. July 2022, man. In between also there was a representations. That is in June. Now, my lord, if your lordship want to say, my lord, there is no straitjacket formula, my lord, so far, my lord, delay in the matter of refiling a writ petition. This will depend on the facts and situation of each case. Now, here your lordship will say, now the Directorate Higher Technical Institution ultimately took a decision in August 2020 and filed a representation. No matter where is the delay, there is no delay. And even if your lordship look into, my lord, the delay, my lord, filing the representation in the division bench order, my lord, which is say, my lord, 8 years, that is also not correct. So my humble submission, my lord, this is a case which comes within the ambit of error apparent on the face of the records. Any other judgment? Any other judgment?
1 minute.
Yes.
Lord, my learned senior has filed a review. My lord will kindly see. He has firstly narrated the whole facts of the writ petition, the prayer in the writ petition. My lord, then he has taken up to the grounds in the writ appeal, my lord. What were the grounds in the writ appeal? So, my lord, he has completely avoided the grounds of the review, my lord. He is relying on the grounds of the writ petition and the writ appeal, my lord.
Yes.
Now, my lord, through this review, my lord, my senior is trying to find fault in the judgment of the Honorable Division Bench, my lord. My lord, my respectful submission, if there are any grievances, my lord, he ought to have approached a higher authority, my lord. Here he is again reopening the whole issue. My lord, he is again narrating the whole facts. My lord, he has raised a question of delay of 8 years, my lord, whether there is any defect. My lord, there is no defect, my lord, because when the learned division bench, my lord, while passing the judgment, the observation of 8 years, my lord. Now, if we take 2014, as my learned senior had stated before this honorable court, and they have approached this honorable court in the year 2022, my lord, that clearly makes a delay of 8 years. Where is the fault? My lord, can my learned senior, my lord, now it is up to the honorable division bench, my lord, in which line the judgment goes, my lord. Whether it requires to be, all discussion is required or not, it is primarily the prerogative of the learned division bench, my lord, the learned court. My lord, can he say, my lord, that there's a fault in the decision of this learned division bench, saying that these aspects have not been gone into, that aspects have not been gone into, this finding is not there, my lord. My lord, can he bring this issue again, my lord, for a rehearing? In my respectful submission, he cannot, my lord. He has to show where is the error apparent on the face of the record. My lord, this is the finding of the court. Now, my lord, if the learned division bench or the learned court comes to a finding that there is a delay, because, my lord, the learned division bench has also, my lord, in consonance with what the learned single bench had decided, my lord, that there is an element of delay in laches. My lord, the honorable division bench has also gone by that. It was also convinced that there is, just merely going into the records, my lord, it was sufficiently convinced that there is delay in laches. Now, when there is a question of delay in laches, my lord, is it necessary for the honorable court to discuss all the issues, my lord? If I am dismissing a certain appeal, writ appeal, at a threshold only on the ground of delay in laches, my lord, do I have to discuss all the other issues, cover all the other issues, my lord? Now, another aspect my learned senior had raised, that regarding the representation, my lord. Where are the representations, my lord? Just because since my senior has raised, my lord will kindly see one representation, and it is not addressed to the government. It is addressed to the respective college. College has merely forwarded the representation. Now, my lord, there is no decision by the government. My lord will kindly see, because since my senior has relied on that letter, my lord, this is at page 123 of the writ appeal and 124, my lord. So, my lord, I will take, my lord, to the last line what it says. This is only a view, my lord. A view of whom? A joint director of higher and technical education. This is not the decision of the government. My lord will kindly see at 124. In view of the above, the government is requested to kindly extend the promotional increment while promoting the teachers of both colleges as well as the deficit grant in 8 colleges from one stage to a higher stage, so and so, except promotion band 3 and band 4 as per EGC regulation 2010. My lord, where is the decision of the government, my lord?
Why you are referring to the content of these letters? What we have to do?
My lord, because my senior has referred to that.
We are not going to reappreciate.
My lord will.
This has been referred only to show us the date.
My lord.
According to him, it was not taken into notice by this division bench while passing judgment. Address on that issue. We are not at all concerned with the merits.
My lord, in my respectful submission, my lord, all these aspects are gone into, but my lord, in my respectful submission, in decision in that regard is not required, my lord. When a writ petition or writ appeal is dismissed merely on the ground of delay in laches, my lord.
See, Mr. Bhattacharya,
my lord.
The question is that in which way the finding of delay is arrived at. That is what is important here. Now, according to Mr. Sen, that while this court had recorded a finding on delay, has skipped taking note of certain letters. So that is where you have to address us. You address us.
My lord, in respect of delay, my lord, my respectful submission, my lord, this honorable court, there is no fault, my lord. Why, my lord? Because
you are not answering.
As, my lord.
You are not answering the thing. The relevancy of letter. Do you want to say that the letter was not at all relevant for considering the question of delay? Is it your plea?
My lord,
you see, your argument is a kind of general kind of argument.
No, my lord,
you should be specific. You see, you should reply to the contention which has been raised by the.
My lord, my respectful submission, my lord, delay will be counted, my lord. The entitlement and the time the writ petition was, the petition was filed, the approach.
Then what about his contention that this the letter was not taken into notice? What do you say about that?
No, my lord, that is incorrect.
Why?
That is incorrect.
Why incorrect?
My lord, there is an observation of this honorable court. My lord, the para 4 of the judgment, my lord, states
yes.
My lord, para 4 of the judgment, my lord, Taking note of the fact that there is delay of more than 8 years in making a representation, the learned single judge, after referring to various judgments, came to a conclusion that no relief can be granted. The representation has been made only in the year 2020, when according to the appellants, writ petitioners entitled to the benefits as early as 2013, my lord. On the sole ground of delay and laches in approaching this court, we are inclined to refer to para 10 of the judgment and order of the learned single judge for rejecting the plea of the appellants writ petitioners on the grounds of delay and laches. Para 10, my lord. Now, of course, para 10, my lord, the learned single judge has referred to this judgment, my lord, which is
that is on the principle of delay.
My lord. My lord, my respectful submission, my lord, as far as the writ, the right of the petitioners are concerned, my lord, firstly, my lord, it is not a continuing right. This is admitted fact, my lord. They are referring to, because in the relief also, my lord, they are referring to one increment. Now, this increment issue, can you raise it after, let's assume that there is not a delay of, let's assume that the delay is not 8 years, let's assume that the delay is, for a moment, my lord, that the delay is not 12 years, let's assume that, my lord. Now, the learned single judge has come to a finding of 12 years, my lord, because starting from the date of issue of the notification, my lord, which issued by the government of Meghalaya, that is year 2010. Writ petition was filed in the year 2022. That is how the learned single judge came to a finding that there is a delay of 12 years in approaching the honorable court. Now, if it is a matter of right, my lord.
But then the 12 years goes. Now it is 8 years in view of the judgment of the
my lord.
So you cannot basically
No, my lord.
justify what single bench has said if that's
no, my lord. Even assuming it is 8 years, my lord. Now,
no,
even
it's a question of assuming. There's
no,
a finding
my
by
lord.
the appellate
Yes,
court.
my lord. It is 8 years. There is a delay, clear delay of 8 years, my lord.
To the single bench order by ignoring what has been recorded by the
no, my lord. Here, the learned division bench has come to a finding that there is a delay of 8 years, my lord, in approaching this, in approaching the government, my lord. Now, my lord, even assuming that if my son, senior says that 8 years is incorrect, my lord, can that itself be a ground of review, my lord, to look into the whole matter? Just on that aspect, my lord, can that be a ground? And my lord will kindly see the grounds taken by my learned senior in the review, if I am allowed to read, my lord. This is at page 6, para 7 onwards, my lord.
Yes.
7A, for that there is an error apparent on the face of record. What is error apparent, my lord? Nothing has been stated. Face of the record, as much as the Honorable Court, while deciding an appeal by judgment and order dated 13/6/2024, has not taken into consideration the acknowledgement by the Joint Director of Higher and Technical Education in its communication dated 24/8/2020 with regard to the entitlement of the writ petitioners, review petitioners of their additional increment on placement in each higher stage of academic grade, and as such the judgment order needs to be reviewed. My lord, can that be a ground? Consideration, non-consideration, that cannot be a ground, my lord. Here the writ appeal is dismissed merely on the ground of delay. My lord, it is not that the moment the right accrued and you have approached this honorable court. Even if it is not 8 years, let's assume it is 6 years, my lord. Even then there is a delay. How do you explain this? Where is the explanation for this delay? merely stating that I have filed several representations. Where are those representations? There should be something on record at least. You file one representation which is on record before the college, which is then forwarded to the government. Where is the representation? How do you establish that you have not remained silent?
You're going to the facts again.
My lord, my apologies. My lord, secondly, my lord, point B. For that the judgment and order dated 13/6/2024 failed to take into consideration. So, my lord, this is finding fault with the judgment. Where is the error apparent, my lord? Taken into consideration that after the acknowledgement of the writ petitioner's review petitioner's entitlement of additional increment on placement at each higher stage of academic grade pay as made wide communication dated 24/8/2020 of the Director of Higher and Technical Education, the writ petitioners, review petitioners had filed representation dated 24/7/2020 before the respondent seeking grant of additional increment as per the aforesaid communication. But in spite of the same, the respondents had failed to grant additional increment and thus the writ petition was filed on 6/7/2022. Now again, my lord, point C. For that the judgment and order dated 13/6/2024 upholding the decision of the learned single judge dated 6/3/2024 without taking into consideration that the fact that the finding of the learned single judge that even after communication dated 28/4/2020 there was substantial delay in approaching this honorable court was erroneous. My lord, here, my lord, the judgment which was relied by my learned senior, my lord, of course I do not have a copy of the same. My lord, there is a clear observation, my lord. It cannot be erroneous facts. You are pointing to all errors in the judgment, my lord. Now, is it subject to review, my lord? The matter is closed. The decision of the division
What
on
is subject to review? If error is not a subject to review, then what is subject of review?
subject, my lord. Here he has my lord, not error, erroneous, my lord. Here he has relied on erroneous.
Erroneous is the result of error, occurrence of error, isn't it?
My lord, by the judgment, very judgment relied by my senior, my lord, it clearly says erroneous. Anything which is the plea is erroneous, plea is taken, my lord. It has to be decided by a higher forum. My lord, can the whole issue be reopened again, my lord? For the judgment and order dated 13/6/2024 upholding the decision of the learned single judge dated 6/3/2024 without taking into considerations the fact that finding of the learned single judge that even after communication dated 24/8/2020 there was substantial delay in approaching the honorable court was erroneous. My lord, what is erroneous? The decision. He is telling the decision of the court is erroneous. The decision of the learned division bench is erroneous, my lord. Now, if it is erroneous, my lord, can on that ground itself the whole thing can be reviewed, my lord. Inasmuch as the learned single judge has failed to appreciate the fact that thereafter the letter dated 24/8/2020, the writ petitioners, review petitioners filed representation dated 24/7/2021. And as the respondents fail to act upon the same, approach the honorable court by filing writ petition on so and so. Again, my lord, point number D, for that the additional increment on placement at each higher stage of academic grade pay is a statutory right inasmuch as the respondents have adopted the scheme contained in the letter dated 31/12/2008 of the MHRD and the UGC regulations. Therefore, there cannot be waiver of acquiescence. So, my lord, again here, my lord, it is finding fault with the judgment of the learned division bench, my lord. My lord, again point E, my lord. For that, the finding contained in the judgment and order dated 13/6/2024, the denial of additional increment is not a continuous wrong and the same could not have any consequences is erroneous. My lord, now erroneous is not one in almost all places. The fact erroneous is stated, my lord. Now erroneous means they are finding fault with the judgment of the learned division bench, my lord. He is pointing to the erroneous decision. He is pointing to the decision, my lord. My lord, whether that can be allowed, my lord, in a review. For that the judgment, point number F, my lord, for that the judgment and order dated 13/6/2024 of this honorable court has dismissed the writ appeal only on the ground of delay. So, my lord, when the honorable division bench in sitting is deciding on the right of the appellant or the writ court in a petition, writ petitioner's rights, my lord. Now, solely if a petition is dismissed solely on the ground of delay and laches, my lord, is there any requirement or a need to go into any other aspect, my lord? That itself ends everything, my lord. There is no requirement. There is the court cannot be compelled to give decision on any other aspect, my lord. Here I am dismissing it on the threshold, that on the delay itself I am dismissing it. Where is the requirement that, my lord, that I'll give a detailed judgment covering all aspects? I'll go into the representation, I'll go into this decision, that, relying on this letter. Where is the requirement, my lord? Merely on delay itself, at threshold itself, that you don't have a case. On the ground of delay itself. Now, my lord, will kindly see the learned division bench has appreciated the decision of the learned single judge, on the ground of delay itself. So, when there is a question of delay, where is the need to go into the details of the case, my lord? Now, my lord, point G also, my lord, will kindly see. For that, it has been categorically stated in the writ petition that the writ petitioners, review petitioners repeatedly brought the issue of not granting the additional increment on placement at a higher stage of academic grade pay before the respondents, and also filed representation dated so and so, but without any result. Therefore, the findings that there is no whisper till representation dated 3/2/2020 by the writ petitioners ventilating the grievances need to be reviewed. So, my lord, he has gone back into the facts of the writ appeal again, writ appeal and writ petition. All the grounds, my lord, will kindly see. My lord, all these grounds are trying to find fault with the decision of the learned division bench, my lord. So, my lord, in my respectful submission, of course, there are some judgments, my lord. If I may be allowed to supply the same during the course of the day, my lord, if my lord permits. My lord, here I am relying on one of the judgments. My apologies, my lord. I may be allowed to supply the same, my lord. This is, my lord, Honorable Supreme Court judgment, my lord. This is.
You see, when you are referring to any judgment,
my lord, so I may be allowed to supply a copy, my lord.
that,
My lord, my apologies. During the course of the day, my lord, I may be allowed to supply a copy, my lord. This is a 2010 judgment,
you
my
also
lord.
have to give a copy to the other side.
My lord, because he has also not supplied any copy to me, my lord. So, my lord, in the meantime, I am just giving this citation, my lord. It is 2010, my lord, 14 SCC 389.
Para?
My lord, paragraphs 13 to 15, my lord. 13, 14, 15.
Yes, read.
Three 9.
My lord, 3. My lord, 389, my lord. This is Union of India and others versus A. Dhurai Raj.
What does it say?
What is the judgment? Achha. My lord, if I am allowed to read, my lord. It is well settled that anyone who feels aggrieved by non-promotion or non-selection should approach the court tribunal as early as possible. If a person having a justifiable, this is on delay, my lord, justifiable grievances allows the matter to become stale and approaches the court tribunal belated, grant of any relief on the basis of such belated application would lead to serious administrative complications to the employer and difficulties to the other employees as well.
Mr. Barsaji,
My lord.
the issue of delay is already
My lord.
already acknowledged. We need not go why delay,
My
how
lord.
delay.
My lord. So, my lord, on grounds of
Only you have to only point out to this court
my lord,
how this review application is not maintainable.
My lord, there is another decision, my lord.
Whether the order in question has been passed.
My lord, firstly, my lord,
erroneously or on errors of facts and law. That's all.
My lord, firstly, my lord, the very judgment which is relied by my senior, my lord, there itself it has been 1997. I do not have a copy of the judgment, my lord. There itself it has been clearly stated where review can be allowed, where review cannot be allowed. Now, my lord, this is a clear case, my lord, where review cannot be allowed. Because even in the grounds, my lord will kindly see, he is only stating that erroneous decision, that this has not been considered by learned division bench, that has not been considered.
We've heard the parties.
My lord.
What you can do?
Very small reply. Very small reply. One thing, my lord, I seek your lordship acknowledge. Why I have elaborated my submission? There is a good reason. Because this review is not before the same bench. Had it been before the same bench, my lord, I would not have gone this long. I would have merely referred to my grounds taken. This is one of the reasons, your lordship, since it is.
I was part of those things before this.
My lord, I felt like this. I'm sorry, my lord, if I have disrupted your lordship. I'm sorry, but I felt that since it is not before the bench. Now, other thing, my lord, coming to the other thing, your lordships. Now, representation, my lord, representation that was not following the letter dated 24/8, my lord. Crux of the issue is this. Because delay, what my London friend is repeating, delay, and I was saying no delay. That was a contentious issue before the single bench. Because in view of letter dated 24/8/2020, there is no delay, there is an acknowledgement. Now my London friend is saying this is an individual opinion. I have read it. This is the opinion of Director of Higher and Technical Education. Now that issue, when my London friend argued this before the single bench, that issue came up. I relied on Supreme Court judgment where he say official communication, once the reason is cited, that cannot be changed by filing an affidavit and making an oral submission. So that contention was not accepted. And in fact, London single judge said, yes, after this letter there is delay. After this letter, my lord, I have pointed out, my lord, on 24 July 2021, there was a representation addressed to the government, Secretary Education Department. So my humble submission, my lord, this is the core of the issue. Had it been touched, my lord.
Even at paragraph 4, paragraph 4 has been pointed out. That is the aspect of the letter dated 24/8
has been referred to.
Has been referred.
Where, my lord?
Yes, just read it out just now.
Wait, it's been referred.
Judgment. You read page 17 of your application or your review petition.
No, I have not come across. It is not referred to.
Which page? Your page 17.
Page 17. On the sole ground of delay and laches in approaching the court, we are inclined to refer to paragraph 10 of the judgment and order of the learned single judge rejecting the plea. Now, thereafter, my lord, he had referred to the judgment, and thereafter he, my lord, reproduced, my lord, division bench has reproduced the judgments. Whatever judgment quoted, nothing else. Now, had there been a discussion that yes, we noticed this letter. Now the reason, without discussing even, the reason cited by the legislation would find no reason to intervene. My lord, that would have been an erroneous decision, I know. But this is an error, my lord. Other thing coming to my drafting, your lordship, 1 and 2. Categorically, I have said paragraph 1 because there is basically one core issue, 24/8. I said 24/8 has not been taken into consideration. Now in other paragraph, simply because I said erroneous decision, my lord, lordship will not ignore the facts which I have placed before your lordship. All that your lordship will see whether the relevant issue has been taken into consideration, has been touched. My humble submission, it has not been. I think it was not noticed, your lordship. What I feel, yes, it was not noticed at all. So, my lord, this is a case, my lord.
We have appreciated your contention, and we'll go through it.
My lord, again, my lord, as far as my lord review is concerned, my lord, I may be allowed to.
What you can do
to supply the judgments in the course of the day,
more often than not, you see.
But my lord, on the ground of
my
lord,
more often than not, I would always call upon the parties to just assist the court in just filing a brief, bullet point synopsis of your argument, and the authorities.
My lord, this authority which I had just relied, my lord, even on the ground of representation itself, my lord, para 14 is very clear, my lord, 14, 15.
You have not supplied a list of your books earlier, so that is very difficult to.
My lord. And my lord, the reasons cited by my learned senior, my lord, in my respectful submission, my lord, no ground is made out for review, my lord. because he has could not point out any error apparent on the face of the record, my lord.
That would be a blanket, you see, opposition, so to say.
There is no error, my lord.
How soon can you do it?
Lordship.
The written argument?
We'll have to give written.
My lord,
Because he will have to cite his.
But am I so far? I have, my lord.
It depends on you if you want to.
No, list of books I have given.
It depends on you.
That is why I'll pray for a week's time, my lord, if it is allowed.
You can do it, or it's up to you.
I'll pray for a week's time, my lord.
When the matter was taken up at the admission stage, the parties have addressed this court on the merits of the petition. Accordingly, on being convinced that the entire matter has been heard, the hearing is concluded, and on prayer made by the parties to file brief written synopsis of their argument along with the authorities relied upon, that is now posted after 1 week.
Obliged, my lord. Obliged, my lord.
Item number 2.
Again, please, Your Honor. Item 2 and item 4 are two appeals filed one by the state and one by the private party, my lord, against the common judgment and order of learned single judge, my lord. In item 4, my lord, your lordship has issued formal notice. Now, item 2, the formal notice has not been issued, my lord. In item 4.
Let us go first to item 2, isn't it?
So yes, my lord, I was praying, but both the matters have been directed to be listed together in the order of 5th July 2024, passed in item 4, my lord. Kindly see that item 4 first, so that I can assist yourself, lordship, in respect of item 2 also, because it is against same judgment and order. And kindly see the order of 5th July 2024, passed in writ appeal 34 of 2024, my lord.
Just a moment. Who's appearing for the appellant here?
I am in item the private 4? Matter.
Item 4.
Mr. Datta is on the screen, my lord. I saw Mr. Datta is. Mr. Datta is mute. It appears.
So this matter, see, this matter has not been admitted.
None of the matters have been admitted.
No, nothing. Both the matters have not been admitted, my lord. What I was praying is that, my lord, item 4, a formal notice has been issued. In item 2, formal notice has not been issued. So in the item 2, formal notice be issued, and your lordship may have it for hearing after 2 weeks.
Mr. Kumar, as far as notice is concerned, first we go into the issue of whether the appeal is admitted or not.
Well, in this case, even that question will not come in, because the only contesting respondent is myself, my lords, who's the writ petitioner. I am the writ petitioner, my lords.
The appellant in item 4.
Yes, Mr. Kapoor. You are Mr. Kapoor.
Lord, I am Mr. Datta, Lord. I beg liberty to enter appearance on behalf of appellant in item 4, Lord.
Your name appears as Mr. Kapoor.
Kapoor.
Lord, that's my colleague. My apologies. I'm logged in through his device, so it's displaying as Kapoor.
Mr. Datta.
My lords. Not
so
items
My lords, insofar as notice is concerned. insofar as notice is concerned, my lords, there is no question of formal notice because the writ petitioner is myself.
Until unless the appeal is
No,
admitted,
if your lordship
We
will
are
see
going.
the order
That's
of
what we are saying.
Absolutely, my lords. And my lords, we had
If your
filed a
lordship
caveat.
will
We've been
see,
served a copy. We're here to assist your lordships.
if lordship will see the order of your lordships in writ appeal 34 of 2024, that is 5th July 2024 order, my lord. Accepts notice on behalf of respondent number 1 and so accepts notice on so and so. So similar order, I was requesting similar order and posting of the hearing of the matter after 2 weeks.
So, Mr. Kumar, what you are,
Yes, lordship.
what you want to say is that you want to be heard on the admission of this appeal.
Yes, my lord. Yes, my lord. Yes,
But
my lord.
after a week's time.
After 2 weeks time, my lordship may have possibly after 10 days also. Because there is a lengthy
So
part had arbitration matter.
we'll not go into the issue of issuance of notice. Of course, Mr. Paul is here. Yes,
We'll have to, because only issue which will come up on later, my lord, if your lordship will hear me on the writ appeal, and Mr. Paul has also got the advance notice of the writ appeal.
You are not on caveat,
So
Mr.
in
Paul.
that case,
We've been served copy.
No, you are not on caveat.
Not
so
on caveat.
Mr.
Oh,
So Mr. Paul has to formally enter into
No,
appearance
my
in
lord,
this
caveat
matter,
is there.
my lord.
Caveat is there.
Then
First,
that is why the purpose of giving.
My lords, caveat is there.
So that your lordship will hear the matter after 2 weeks, my lord.
Caveat
on
is
that issue.
discharge, not discharge.
Not discharges it. Lordships can discharge the caveat. My lord. Give me the caveat. Number?
yes, let me that. Or prayer made by the Learned Advocate General. This matter to come up for admission hearing on the after 2 weeks. In both matters.
My lords,
Both matters, my
may I pray, my lords, a fixed date,
What did you want?
subject to, my lords, your lordships kind convenience.
Yes,
after
Mr.
2
Kumar,
weeks.
you suggested it.
Yes, whatever did my friend suggest.
Mr. Datta, what would you be your convenient date? If you said
Lords,
2 weeks from today, then means
what? Lords, we may have it in 2 weeks, Lords. We could have it on the
17th or the
on the
19th.
16th or 17th.
17th or 19th,
is
lords,
work.
subject to.
Lords, 19th is workable.
Yeah.
Lords, 17th is also workable, Lords.
So
Lords, maybe have it on the 17th, my lords, subject to my lords'
Yes, Mr.
convenience.
I can't hear.
My lords, I would only pray if your lordships kindly have it on the 19th. My friend here, my lords, who's coming from Delhi, has some difficulty.
19th, your lordship may have it. 19th
So,
is fine.
Is 19 okay with you, Mr.
Lords,
Datta?
19th is Lords, 19th is workable. I'll certainly make it a point to come down and assess the court physically.
That would be
on the
very,
19th.
very convenient. Sometimes,
Lords.
sometimes it's very difficult on the
virtual mode.
My lords.
Virtual mode.
This is matter on 19.
Item 4 as well, my lords.
Yes, 1 and 4, 2 and 4.
2 and 4.
Item number 3.
Great.
Yes.
Please, Your This is a reappeal against the judgment order dated 18/4/2024, my lord, passed by the Honorable Single Judge in WPC number 474 of 2022.
So this matter is ready for hearing.
Yes, Your Honor. Yes, Your Lordship.
Yes. So we'll post the matter for hearing.
Yes, Your Lordship.
How long?
We'll hear it now, my lord.
We'll post the matter for you. See, we have it is in the admission column. But
Already
it is
admitted,
noticed,
my lord,
or no, yes,
last time.
it is noticed that it's already admitted.
Yes, sir.
Already admitted. So we'll fix it for hearing then.
Yes, Your Lordship.
How long? After
2 weeks.
Short date will do, my lord. After 1 week also will do.
As Your Lordship pleases.
Heard letter counsel from the parties who has submitted that this matter is ready for hearing. Accordingly, as prayed for, this is matter after 1 week.
And your pleasure.
Item number 6.